Okay, I'm Linda Park, and just to kind of connect who I am and why I'm here, I'm the director of the library. And I guess one of the reasons I know a little bit about copyright is I also have a law degree, so I didn't learn much about copyright in law school, but I've kind of been forced to do it in my position here, so hence I'm kind of going to do a short presentation on copyright to just give you some background. Okay, copyright, what is it? Well, to kind of paint a little bit of a picture, if you think about, you have a gentleman, he has a house and he has a car, and somebody goes into his house that shouldn't, that's trespass, that's a crime, right? Everybody agrees that? Somebody takes his car without permission and drives off with it, that's a crime. Well, what if the same gentleman writes a song, makes a book, films something, and somebody steals that piece of that book or that work and starts profiting from it? Would you all agree that that's a crime too? That's copyright. That's using someone's intellectual property, and that's what we're going to talk about today. That's the concept of copyright. Okay, and it's really everywhere. If you look around, you see it in the DVDs that you watch, the television programs that you see every day. When I listen to the Yankee broadcast on the radio, before the broadcast comes on, they talk about copyright and that the broadcast is copyrighted and you can't use it. And actually it's going into a new area now. I just got something the other day from my husband. The ABA has said that evidently it's going into the fashion industry. Evidently the House of Balenciaga and I think Alexander McQueen are suing Steve Madden for evidently stealing some shoe designs. And evidently what's going on is there isn't a current copyright law that it really applies to the fashion industry, but evidently Chuck Schumer is working with a Harvard law professor to develop a copyright law that would then apply to the fashion industry. So it's really everywhere, and it's going into new areas as well. Now, I thought I'd start by talking a little bit about the history of copyright, and it's been around for a long time. We go back to early England and something called the Licensing Act. And it actually started as a form of censorship, in that in England nothing was published that was critical to the crown. And if an author wanted something published, he had to actually get a special license from a group of publishers called the Stationery Company, who censored what was produced. If it was critical to the crown, they didn't agree to produce it. And what happens if it was going to be published, the authors literally had to turn their works over to the stationery company for publishing. And then guess who got the profits? Not the authors. The publisher did. Now this act actually expired in 1695. And in 1710, I believe, in England, they developed a new copyright law called the Statute of Anne, and it was called a bill for the encouragement of learning and for securing the property of copies of books to the rightful owners thereof. This is actually the first copyright act in the entire world, and it gave authors copyright protection limited to a maximum of 28 years. So their work was protected for 28 years. After that, the work belonged to the public. It became part of what we call, and you've probably heard, the public domain. And if something is in the public domain, it means it's not protected by copyright anymore. And everybody can use it without a problem, without getting permission. Now, what about the United States? Because we're just talked about England. Well, the founders of the country, the writers of the Constitution, felt that a uniform copyright law was extremely important. They wanted well-informed citizens, and one way to do that was to make sure that they had access to knowledge. That was critical. So what the framers did was focus on the positive components of the Statute of Anne as they began to develop copyright law in this country. And if you like to read legal things, the U.S. Constitution, Article 1, Section 8, where the powers of the Congress are delineated, says that the Congress shall have the power, and one of those powers is to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. In other words, the authors and inventors are entitled to reap the profits from what they've invented or written. Now, what this does is it says that creating copyright law rests with the National Congress. And it's important. It is on a par with declaring war, coining money, and collecting taxes. The founders really thought this was critical. And so critical, actually, that in 1976, the Congress actually abolished all state copyright laws. The power of copyright rests completely with the federal government. It's a federal preemption. The states have nothing to say about it. So the bottom line is that copyright's been around for over 300 years. I don't think it's going to go away anytime soon. And we think it's important that everyone here have just a basic understanding of what is and isn't permitted. Now, what Congress did with the copyright law was give the copyright holders exclusive rights to reproduce and market their works for a period or a limited period of time. So this is kind of an incentive to authors to write and inventors to invent. That way they have no competitors for their copyrighted works. And another important thing to remember is copyright protects the expression of ideas, not the ideas themselves. And copyright duration actually varies depending on when something was published, and there are a number of sites on the internet, including this one, and I think you may have some of this presentation as well as one of my handouts in the presentation material that you were given today. And this is a site from the University of North Carolina, and it's a chart explaining when something was published and when it would come out of copyright and when it would be in the public domain. And this is freely available on the internet if people are trying to figure out if something is copyrighted or if it's out of copyright. Now, how do you acquire copyright protection? It's actually immediate as soon as you create something. Now, in the past, the work had to be actually registered with the Copyright Office or contain a copyright notice. You don't have to do that anymore. So the next question is it necessary to register? Well, you probably should, because it's a prerequisite to filing a copyright infringement lawsuit. So if you've written something and somebody infringes it and you haven't registered with the Copyright Office and gotten the paperwork done, you can't file a lawsuit until that registration's done. So you need to have a timely registration so that this will allow the copyright holder to claim statutory damages. In other words, you've been hurt because somebody infringed on the copyright on your material. And it's fairly simple to register. You just go to the copyright website and you can literally register online. Now, if the rights of a copyright holder are actually violated, he can file a lawsuit, again, in federal court, not state court, to issue orders to prevent additional violations and to award him money damages. And the penalties for copyright infringement can be extremely steep, $150,000 or more, and attorney's fees, and not all attorneys run cheap, so it can get very costly. One example was back, I think in the fall, a Boston University student had to pay over $675,000 because he was downloading music, and I think he was also forwarding it to his friends, and he got tagged for a hefty bill. About 6 months ago, back in Orchard Park, outside of Buffalo, a man there was sent to prison for copyright infringement, and he lost his business. He was doing something with medical software and he didn't have the copyright, and he lost everything and a lot of people were out of work. Now, are there any limitations to this exclusive rights of the copyright holder? Well, there actually are, and everybody's probably heard of fair use. This is the most common exception to the rights of copyright holders. And it's actually now a statutory right encoded in the Copyright Act. And it limits the exclusive rights of the copyright holder. And it's an exemption that allows the user, in our case in academics, to use the copyrighted work without permission. In other words, you can scan it, you can quote it, you can share it. Without this exemption, quoting from copyrighted works, providing students with copies of someone's article or book would all be infringements. Now, what is fair use? It's actually pretty simple to understand because it's basically based on a balancing of 4 different factors. And you look at each factor and apply them to your particular situation. You know, you want to use an article in class or you want to do something else, and you look at the factors and apply it to your situation. The secret to fair use is to be consistent, to recognize that reasonable people can disagree. The law is not black and white, and fair use is really interpretive. And what one person may think of as fair use, someone else may think it is not. It's all interpretive, but the main thing is to try to do the right thing and act in the spirit of the law. Now, what are the 4 factors? Well, the first factor is what's the purpose of your use? And if the purpose of your use is nonprofit or educational, as in, you know, you're working in the college and you're getting information together for students, that factor would then favor fair use. On the other hand, if you're a for-profit organization and your use is commercial, that factor would really work against fair use. Another factor is what's the nature of the work that you're using? If it's factual, if it's nonfiction, if it's a published work, then this factor would favor fair use. If, on the other hand, what you're using is extremely creative, it's a work of fiction, it's not published, then this factor would kind of lean against fair use or oppose fair use. Third factor, how much of the work are you using? Just a little bit? Is the portion that you're using not central or significant to the entire work? Well, then this factor would favor fair use. On the other hand, if you're using the whole thing, or you're using the central or core portion of the work, then you might want to think again, because that factor opposes fair use. Last factor is what's the effect of your use of this item on the marketplace? If it isn't a significant effect, then that factor would favor fair use. You're only making a few copies. On the other hand, if the cumulative effect of copying this or using the work is to substitute for the purchase of the work, then that negates, this factor would then oppose fair use. I've had, at times in the past, in my position here, faculty members ask us to borrow, for example, a video from another lender. And then they wanted us to copy the video for them so that we didn't have to buy it. And we said, we can't do that. If it's that important that we need the video, then we need to buy the video and find the money to do that. Because there we would be, again, we would be copying something to avoid purchasing it and, again, taking away the profits from the creator of the video. Again, if you're another effect on the market, if you're making lots of copies, you're using it semester after semester, you're making it accessible to people in a public forum. In other words, you're putting it out on the internet in some fashion where anybody and everybody can access it. There's no password protection to get at the material. Then this factor would oppose fair use. You don't need to satisfy every factor for fair use to claim the fair use exemption. Where your factors favor fair use, favoring fair use outnumber the factors weighing against it, then relying on fair use is justified. If you come out with fewer than half of the factors in favor of fair use, you probably should think about getting permission from the author, the the publisher, whatever the case may be. If you're 50-50, maybe you better get permission, or if you're not, you don't want to do that, get an opinion from the college attorneys, because at least if the attorney makes a mistake, it's his malpractice. Now, there is a good faith, fair use defense for educational institutions, and it's actually a special provision for institutions, educational institution, who believe their work constitutes fair, their use of a work constitutes fair use. In other words, you've looked at the material, you think, you've gone through the analysis, and you decide that it is a fair use. Even if at some point it's called into question, you're sued for copyright infringement, and it's found that the court says, yep, we agree, this is infringement. If you made a good faith attempt to comply with the statute, you had a reasonable idea in going through the analysis, and you felt that this was a fair use, if you do that in good faith and the court finds that, then even though you need to stop the practice and you've been found guilty of copyright infringement, you won't be charged statutory damages. So you'll be exempt from fines if you made a good faith attempt to comply with the copyright law. And you just, again, reasonable people differ. There are various fair use checklists online. Here's a list of some of them: Columbia, Cornell, Indiana University, that give you the various factors, and if you have a specific instance where you want to use an article or something like that, you can work your way through the factors and make a decision yourself whether it's fair use or not, and you can do the analysis. There's also, you're going to find, because this is such a major thing, lots of universities have dedicated large portions of their websites to information on copyright. Stanford, Columbia, Cornell, all of them have lots of information out there on copyright, in addition to fair use checklists that faculty can look at to try to decide if their use is in fact fair use. Now, what about the electronic content? Is it the same or is it different than the print materials? Well, the same rules apply to electronic content as do the rules for print materials. You use the same four factors in trying to develop your best practices for e-reserves, or for, in this case, we're using Moodle, so it's not exactly e-reserve, but it's the same idea. And with respect to the fourth factor, the effect of the use on the market of the work, if materials are being made available online, one of the things that you can do to control the access is make sure that you limit access to students in the institution or the classes. And by password protecting it, so only people in the classes can get into Moodle, into your site, and read the articles. And then you terminate student access at the end of the semester, so you really control who can access the materials. In some cases, there's questions about, can we link directly from Moodle to articles in the databases that the library owns? Well, yeah, you can do that if the library subscribes to the database and there are no, and this is critical, and there are no licensing restrictions on the article in the database. And I'll talk about this in a minute. If there's an article in one of our databases that you want to link to and there's no licensing restrictions, you can do that, but you need to link through our proxy server. In other words, you need to go through a password protect for the students need to go through the proxy server to get to it. In other words, they have to put in a password to get into and find the article. And if people want to do that, the key there is to talk with our electronic resources librarian, and she will tell you how to do that. Now, some journals in the databases actually do have licensing restrictions on linking to the articles. And if there's an article that you want your students to read, and it's in the database, the best place to look for that restriction is in the article's abstract. And be aware, not all articles have any restrictions at all. Some of them you can link to without a problem, but there are some that you cannot link to because there are restrictions. The best example and the most severe example is the Harvard Business Review, which is available in the Business Source Premier Database and EBSCO. Some of the ACEP classes have been using articles from this journal as required readings. But some of the articles in this journal have a notice of use restrictions in the abstract that is extremely severe. And this is what it looks like. And you can see in the bold, it is not intended for use as assigned course materials in academic institutions. And academic licensees may not use this content in electronic reserves, electronic course packs, persistent linking from syllabi, or by any other means of incorporating this content into course resources. It's extremely limiting. You can't use it. If you need it, you need to get permission from Harvard, and they have all the information at the bottom. Harvard wants to make lots of money. But if you want to use the Harvard Business Review and have your students read this as required reading, you need to get permission to do that. And why is it important? Because when the library subscribes to these databases, we agree when we contract with the databases to abide by the copyright, contractual, and other licensing restrictions in those databases. And if we don't, and in this case, EBSCO becomes aware of a breach on our part, they can suspend our access to the database. They can cut us right off, which means all the students on campus and off campus will no longer have access to EBSCO. And you think, well, how do they know? Well, EBSCO can see patterns of where people are coming from to view the article. And if they're all coming from the same page, they're probably coming from some type of a syllabi or a course management system. So they can figure it out if the item is being hit by the same place over and over again. And they could literally suspend our use of the database until we stop the infringement. The other thing we shouldn't do is make digital or scanned copies of database articles and put them on Moodle for downloading. Again, what you need to do is link to the article through our proxy server, and again, getting help to do that if you need that. If in doubt, tell your students the information they need, give them the citation, and direct them to the database to locate the article. Again, assuming there's no licensing restrictions on the articles. Now, what if we have something in the library in print and you want to use it as a required reading? I think this is okay, we can do this. And the process for doing that is, if we have it in print, we can make a print copy of it for you. You can add a note to the top of the first printed page saying that the material may be protected by copyright, and then the material could be scanned as a PDF and placed on Moodle. And as long as you restrict access to the students in your class and terminate their access at the end of the semester, I don't think there's a problem with this. Now, the TEACH Act, I don't really think applies here. It's talking about allowing the use of copyrighted works in distance education, and the college here has not adopted that, so I'm not really going to go through any of that. But what I thought I'd end with is why I think this is important. First, why copyright is important. First, it's a matter of risk management. Failure to follow appropriate copyright principles exposes the college to a lot of risk and liability. And as important, maybe more important, I think, is academic integrity. We expect it from our students. We're going to gig them if they plagiarize, but we as faculty need to set an example by abiding by the copyright limitations and restrictions, because otherwise I think what we've done is create a double standard, and I don't really like that. So we need to do it right as well, because we expect our students to. And that's copyright in a nutshell. Any questions?
Thanks, Linda.